Public Accommodations, Discrimination Prevention in Maryland. The Maryland Commission on Civil Rights, or MCCR, represents the interest of the state to ensure equal opportunity for all through enforcement of Titles 20 of the State Government Article and 19 of the State Procurement and Finance Article, Annotated Code of Maryland. MCCR investigates complaints of discrimination in employment, housing, public accommodations, and the state's commercial non-discrimination policy for members of protected classes that are covered under those laws. What is a protected class? It is unlawful for an owner or operator of a place of public accommodation or an agent or employee to refuse, withhold from, or deny to anyone the accommodations, advantages, facilities, and privileges of a place of public accommodation because of race, sex, age, color, creed, national origin, marital status, sexual orientation, gender identity, or disability. The law protects you in the following settings, including, but not limited to, restaurants, hotels, theaters, bus and transportation services, recreational and aquatic centers, governmental facilities, gas stations, department stores and retail establishments, sidewalks, parking lots, and other public surface areas, office buildings and commercial establishments, museums, amusement parks, and other public attractions. These legal protections also include entrances and exits, restrooms, and customer sales and service. Public accommodations discrimination may happen when services are denied outright, such as when someone is refused admission to a public place. Discrimination may also occur in other ways, such as when someone is offered less favorable service than others, or when a physical barrier or other issue makes services inaccessible to someone who has a disability. Here are some examples of potential discrimination in public accommodations. A bar or entertainment venue won't let you in because it's full, but you see people of other races allowed in after you were turned away. You are not served at a restaurant because you are a person with a disability. A store or restaurant gives discounts to people of the opposite sex, but you still have to pay full price. A restaurant owner refuses to serve a customer wearing religious head coverings. A delivery service will not deliver to a largely minority neighborhood, but serves surrounding non-minority neighborhoods. A taxi driver refuses to allow persons with disabilities in her cab. A retail establishment will not provide handicapped accessible parking to patrons with disabilities. A grocery store does not provide a wheelchair accessible entrance. A private membership club solicits members from the general public but denies admission based on national origin. A public library bars service animals from entering the facility. A recreation center denies a person with a disability the right to swim during pool hours for the general public. A security guard follows people of certain races around the store, but not people of a different race. An airport refuses to allow a person with diabetes to bring care supplies, including syringes, lancets, and insulin through security checkpoints. A courthouse refuses to allow persons with disabilities to have breaks to check blood sugar levels, eat a snack, take medication, or use a restroom. Closed captions. On request, a place of public accommodation may not fail to keep closed captioning activated on any closed captioning television receiver that is in use during regular hours in any public area. However, a place of public accommodation is not required to make closed captioning available if no television receiver of any kind is available in the public area, or the only public television receiver available in the public area is not a closed captioning television receiver. Service animals. Service animals may accompany people with disabilities in places of public accommodation. The animal must be allowed in all areas of the facility where the public is normally allowed to go. Businesses may not charge a fee or deposit as a condition for admitting a service animal. Allergies and fear of dogs are not valid reasons for denying access or refusing service to people using service animals. Reasonable accommodations. Under Maryland law, reasonable accommodation means making a place of public accommodation suitable for access, use, and patronage by an individual with a disability without danger to the individual's health or safety, and undue hardship or expense to the person making the accommodation. It's important to note that, while public places are required to provide reasonable accommodations to persons with disabilities, the accommodation provided does not have to be the specific accommodation requested by the patron. The owner, operator, or their employees may provide alternative accommodations that safely and efficiently meet the disability-related need. Here are some common questions and answers about situations involving reasonable accommodation requests. Question: are all restaurants be required to have brailled menus? No, not if waiters or other employees are made available to read the menu to a blind customer. Are public businesses required to provide free food to service animals? No, just as the owner of the service animal must pay for their food, food for service animals must be purchased. Will a clothing store be required to have brailled price tags? No, sales personnel could provide price information orally upon request. Is a grocery store allowed to require face coverings for entry, even if the patron has a disability that prevents them from safely wearing a mask? Yes, in order to prevent the spread of communicable diseases such as COVID-19, public places may institute policies, including but not limited to face mask policies. Under certain circumstances, the public place may be required to provide accommodations so that persons with the disabilities can participate in or benefit from the programs offered, or goods or services that are provided, such as allowing customers to order online with curbside pickup or no-contact delivery in a timely manner, allowing customers to order by phone with curbside pickup or no-contact delivery in a timely manner, allowing a person to wait in a car for an appointment and enter the building when called or texted, or offering appointments by telephone or video calls. Will a bookstore be required to maintain a sign language interpreter on its staff in order to communicate with deaf customers? No, not if employees communicate by pen and notepad when necessary. Exemptions. Maryland's laws prohibiting discrimination in public accommodations do not apply in certain circumstances, such as a private club or other establishment that is not open to the public, except to the extent that the facilities of the private club or other establishment are made available to the customers or patrons. For instance, a golf club that is typically restricted to members only may be a private club under the law. However, if the club hosts events that are open to the public, such as weddings and festivals, the club may then be required to comply with Maryland's laws prohibiting discrimination in public accommodations. Proprietors or employees of any establishment may deny service to any person for failure to conform to the usual and regular requirements, standards, and regulations of the establishment, provided that the denial is not based on discrimination on the grounds of race, sex, age, color, creed, national origin, marital status, sexual orientation, gender identity, or disability. For example, if a restaurant or nightclub has a dress code that prohibits athletic wear, the restaurant owner or employees may refuse to serve patrons on that basis. However, it would be illegal for the restaurant to exclusively apply the no athletic wear policy to African American patrons. Harassment on the basis of a protected class and retaliation for filing a complaint or being involved in the investigation of a complaint are both prohibited under the law and enforced by MCCR. If you believe that actions have been taken against you based on a discriminatory animus, it is imperative that you contact our agency immediately to initiate an inquiry, so that we can assist you in determining if you have been a victim of public accommodations discrimination. Our trained intake staff will guide you through the intake process and through a series of questions and interviews, help you analyze your situation to determine if the actions taken against you meet the threshold of being considered discriminatory. Filing a complaint. The first step to filing a complaint is to initiate an online inquiry using the form on our website, mccr.maryland.gov. You may also contact us by phone, 800-637-6247 or 410-767-8600. Maryland Relay 711. Intake. The intake unit will contact you to schedule an interview, either by phone or in person, with one of our trained intake officers to complete the process. You must complete the interview and sign and return any and all necessary documents, including the charge of discrimination, to the Maryland Commission on Civil Rights before the complaint is officially filed. Charge investigation. Once a case is assigned for investigation, the investigator will conduct an impartial investigation to determine the facts through interviewing witnesses, gathering and analyzing documents, conducting on-site visits, and conducting fact-finding conferences. Voluntary resolution. MCCR offers parties many opportunities to resolve charges of discrimination. Successfully resolving the case through one of these voluntary processes is often expedient and beneficial for both parties. Methods of resolution include settlement and conciliation. Issuance of written findings. After completing an investigation, the investigator will draft a written finding, which will clearly state the positions of the complainant and respondent relative to the allegations made in the complaint, and identify the results of the investigation. Finding of probable cause. If the investigator finds that based on the gathered evidence, it appears that there is probable cause to believe that the complainant was discriminated against, the investigator will take the necessary steps to resolve the matter. MCCR staff is responsible for making a good faith effort to conciliate these matters. Conciliation efforts focus on bringing the discriminatory practice or policy into compliance with the law and providing full remedy and relief for the complainant. However, if conciliatory efforts fail, the case will be forwarded to the Commission's Office of the General Counsel. Finding of no probable cause. If the investigator finds that based on the submitted evidence that there is no probable cause to believe that the complainant was discriminated against, a written finding of no probable cause will be issued, and the case will be subsequently dismissed. The complainant then will have 15 days to file a written request for reconsideration to the Commission's Deputy Director. Once the Deputy Director has reviewed the complainant's request, a decision will be made to either uphold the finding issued by the investigator or remand the case back to the investigator for further investigation. Education and outreach. The Maryland Commission on Civil Rights provides outreach services, information, and training support to agencies and individuals in Maryland on issues affecting equal access and opportunity. Through our community outreach and education program, we offer workshops and seminars to institutions, businesses, and organizations throughout the state. Thank you. We look forward to working with you to accomplish our vision to have a state that is free from any trace of unlawful discrimination.